This podcast is brought to you by Bloomberg Law. For more information about our professional services for the legal industry, please call 212-617-6569.
You're listening to Bloomberg Law. I'm Josh Block. As of this recording on Thursday, May 3rd, the verdict is not yet in Oracle's intellectual property case against Google. Oracle is suing over Google's use of the Java programming language. Java is used in the Android software that runs more than 300 million smartphones. I'm joined now by legal reporter Karen Gullo, who's covering the trial for Bloomberg News. What is this lawsuit about?
It's a copyright and patent infringement case. Oracle alleges that Google infringed its patents and copyrights that it holds for the Java programming language when Google used that programming language to develop Android, which is the operating system that runs on 300 million smartphones.
What will determine whether Google was required to acquire a license to use this software?
Oracle says in court documents and in its arguments by its witnesses that Google was required to have a license, and that other companies, RIM and Microsoft and other companies have taken a license for Java to develop, do their own implementations, and that it's important for Java users to license the technology because it preserves, the integrity of Java, so that everybody can use Java applications. Google contends that this is not the case. It wasn't required to license Java, and that whatever use that it made of Java was what's called fair use.
Fair use is a defense to infringement. They're not conceding that they infringed.
They're not conceding they infringed. They are conceding that they did use portions of Java in Android. In fact, one of the jury questions that's being deliberated right now is, has Oracle proven that Google's conceded use of the following, which are three examples of code and other things. So in that respect, yes, Google has conceded using some of Java in Android, but again, their claim is that it was fair use, or it's what's called de minimis, meaning that it's so tiny. There's actually about 9 lines of line-by-line copying that was made of Java in Android out of 15 million lines of code in Android. Google claims that this falls under the de minimis rule, meaning it's so small that it can't, there can't be a legal claim against that tiny amount.
What was Oracle's best argument that Google is required to license Java?
They had a lot of their software engineers and their software specialists testifying before the jury, making the argument that other companies have taken a license for Java, that Google is the only company that has not taken a license for Java.
What were the highlights of the testimony?
Well, there was testimony by a former Sun Microsystems CEO, Jonathan Swartz, who said that while Sun might not have liked what Google was doing, after Google and Sun could not reach an agreement on co-developing Android back in 2006 and 2005, there were discussions between the two companies, and that came out in testimony and documents in the trial. Schwartz said that after those talks didn't come to fruition, Google, went its own way and decided to develop Android on its own using Java. And even though Sun might not have liked that, he testified that he did not believe that Sun had grounds to pursue litigation against Google because in the end, the parts of Java that were used by Google were free to use.
The two famous chief executives of each company, Larry Ellison of Oracle and Larry Page of Google, testified in court. Tell me what that was like.
Ellison's testimony, in his testimony, he talked about efforts that Oracle had made to develop a smartphone with the Java programming. And this was testimony that he gave under questioning by Google's attorneys. Because one of Google's arguments is that Oracle missed the boat on the smartphone, on the very profitable smartphone business, and this lawsuit is about its trying to capture some of those profits by insisting that Google take a license for Android, which is running on 300 million smartphones. So Ellison's testimony was that Oracle did explore the idea of developing a smartphone with Java and then decided that it would be a bad idea. And he talked about some of the companies that Oracle had looked at considering acquiring or working with, and that ended up getting a lot of attention because it was not known. I don't think Oracle's smartphone efforts had been disclosed as fully as he disclosed them under questioning by Google's attorneys. As far as Mr. Page is concerned, he was asked about a lot of the documents and emails that Oracle is using in the case to show that Google's executives knew at a very high level that they had to take a license. Mr. Page testified that Google wanted to use Sun's technology, but they weren't able to come to terms on a business partnership, and he said, quote, "We went down our own paths."
What's at stake for both companies?
For Oracle, if they were to win in this case and the jury decided that there was infringement, they are claiming up to $1 billion in damages, and they are also seeking an injunction, which would be a court order preventing the sale of products that infringe their copyrights, which would be Android, which could force the taking of a license. Oracle also claims that what's at stake is continuity and consistency in the world of Java programming, that an independent implementation of the Java programming language fragments Java in a way that's not good for the programming world, and it's a very large world of Java programmers out there. For Google, stakes are, that if they were to lose the case and infringement were to be found, they'd probably contemplate taking the license or facing a damage verdict. The jury will decide how much in damages Google will have to pay, and then the judge would decide whether or not an injunction was needed, and that wouldn't come until after the verdict is rendered by the jury, and that wouldn't happen until the end of the case.
Do you have a sense of what's at stake for copyright law as it pertains to programming and computer languages?
There are some in the open source world who believe that this is sort of an important case and could have a lot of implications for programmers. There's a researcher from a UK-based outfit called Leading Edge Forum, which is a global research and advisory forum for corporate IT chiefs. And what he said is that a finding that these parts of Java that Google used are copyrightable would be fairly catastrophic for the U.S. software industries, because common functions that programmers use, like these application programming interfaces, would become protected or could potentially become protected, and that could lead to more lawsuits. And he's quoted in one of our stories as saying, if you're looking for a case where the U.S. legal system might throw the golden goose under a bus, then this one is a pretty good candidate.
Do you have any guesses on a likely outcome?
Oh, I would never guess. That's not wise to do in a case like this. The jury has been deliberating this is their third day of deliberations, and we're just waiting and standing by until they reach their verdict, in which case we'll run to the courtroom and be ready to go.
That's Karen Gullo of Bloomberg News. For more information about this and other topics, subscribe to BloombergLaw.com. You can find our recent programs on our YouTube channel. Follow our daily updates on Twitter. Thank you for listening.
Copyright 2012 Bloomberg Finance LP, all rights reserved. The views expressed herein are those of the speakers and not of Bloomberg Finance LP. These discussions are for informational purposes only and should not be construed as legal advice, which has to be addressed to particular facts and circumstances involved in any given situation. Bloomberg Finance LP and its affiliated entities do not take any responsibility for the content contained herein and do not make any representation or warranty as to its completeness or accuracy.